Okay, class, Chapter 1, Part 8, and in contrast to Part 7, which was very unimportant, this part is extremely important. So we're going to talk about classification of laws, and there's two types of classifications we're going to talk about. One is substantive versus procedural, and the other is civil versus criminal. Okay. So, the difference between substantive law and procedural law. Substantive law is defined as consisting of all laws that define, describe, regulate, and create legal rights and obligations. So, for example, in the criminal law area, a statute that would say that the killing of another person is homicide would be a substantive law. In the civil end, a statute that said that to make a binding contract you have to have an offer, an acceptance, consideration, legality, and capacity would be a substantive law in the civil side. Procedural law consists of laws that outline the methods of enforcing rights established by substantive law. A way of looking at it is it's simply the process that one has to go through. So in the criminal law, a process that says that the defendant must make the first closing statement in a trial would be a procedural rule. In a civil case, a rule that said that after the plaintiff files the lawsuit, the defendant has 30 days to file an answer, and if they don't do so, they lose the case. That would be a procedural law. Now, there's a tendency to overestimate the importance of substantive law and underestimate the importance of procedural law. This is particularly true in criminal law, because if you're a criminal defense attorney, the chances of winning your case for your client probably rely more on procedural law than they do on substantive law. And that is because you're going to try and keep out as much evidence as possible against your client. So procedures such as the warning given to a perpetrator under Miranda, you have the right to remain silent, etc., becomes extremely important. So we'll be talking about substantive and procedural law in both criminal and civil. So that brings us to the next classification, the difference between civil and criminal law. So civil law spells out the rights and duties that exist between persons and their governments, as well as the relief available when a person's rights are violated. So this can be situations where it's one person has a dispute with another person, or a person has a dispute with an artificial person like a corporation or a limited liability company, or two artificial beings like a LLC and a corporation have a dispute, or a government can be involved. So it can be an individual suing the U.S. government over a civil matter. Criminal law is concerned with the wrongs that are committed against the public as a whole. It's important to note with criminal law that the conflict is between the government and the alleged perpetrator, the defendant. The victim is not really a party to a criminal case. The victim has a limited role. The victim may or may not be a witness in court, and then there are some other rights that the laws have established fairly recently for victims, such as the right to be notified when the convicted person is being released from jail, things like that. But otherwise, the victim plays a very limited role in the criminal law. In cyber law really isn't a category like criminal or civil, but we talk about it because it's become important recently, and it refers to the laws governing electronic communications and transactions and the legal issues that are involved there, like we talked about before with electronic signatures. Okay, so this is a very important chart we're going to go over. It's one that you should probably memorize because it shows the differences in some of the areas with regard to criminal and civil law. So purposes. So the purpose of the criminal law is punishment and deterrence. We punish the perpetrator, the defendant, and it is sort of a retribution. We're punishing him to get back at them for what they did. But also, one of the purposes is deterrence. We're trying to deter that person from committing future crimes. We're also trying to deter the general public, because when the general public sees somebody being punished for doing something that's a violation of the crime, it tends to make them not want to do the same thing. So it has a deterrent effect. Okay, let me close this up. Alright, so in civil law, the purpose is primarily compensation to the victim. We're trying to, as the law says, make the victim whole, or put the victim back in the place that they were in beforehand. Okay, so if you buy a car and the car turns out to be a lemon, and you sue the people who sold it to you, the remedy might be either getting your money back as damages to make you whole, or it may be to give you a new car that performs the way you expected it to do so. In some situations under the civil law, you may seek an equitable remedy like an injunction. So you may be trying to enjoin your neighbor from building a fence on your property. You don't want them to do so, and damages are not going to be satisfactory because it's taking up some important part of your land. So you seek an equitable relief. Again, the parties are different. In a criminal case, it's the government versus the alleged perpetrator, we call the defendant. In a civil case, it's a private plaintiff and defendant. Now the next one, the standard of proof, is extremely important. Okay, in a criminal case, the standard of proof is beyond a reasonable doubt. In a civil case, it's a preponderance of the evidence. So the government, in a criminal case, has to prove the case by beyond a reasonable doubt. So lawyers look at it like a scale. So let's suppose this marker is the scale. The scale has to tip all the way in favor of the government to meet the standard of beyond a reasonable doubt. It's a very high standard. Okay, in a civil case, the scale only has to tip slightly in favor of the plaintiff, the person bringing the lawsuit, in order for that person to win. So that is a way of explaining sometimes the difference of outcomes in certain cases. So in a civil case, what we often say is that it's more likely than not that the facts are the way the plaintiff says they are. So it's just a slight tilting of the scale in favor of the plaintiff. So in both situations, the plaintiff or the prosecution is required to go forward and present the evidence first. Notice the difference in terminology. In a criminal case, the person bringing the case is referred to as the government, the state, the U.S. government, or the prosecution most often. The person who is brought to court, the alleged perpetrator, is referred to as the defendant. In a civil case, it's the plaintiff bringing the case, or sometimes the petitioner is the word that's used, and the person who the case is brought against is the defendant or the respondent in some cases. So those are the differences between criminal and civil law in accordance with this chart. So we're going to stop there with this video 8, and again for chapter 1 the magic word is federalism.